Delighted to be joined today by Elizabeth Graves and Paul Fontes, who are partners in the Employment, Labour and Pensions team at Evershed Sutherland. Paul and Elizabeth are going to be sharing all of the content today. And there will be an opportunity for you all to ask questions and share experiences at the end, towards the end of the session. That said, if you have a burning question or thought that you want to share during the course of the session, then please do either message me or put your hand up, and I'll be sure that we attend to that in real time. But for now, I'd like to pass the mic, as it were, over to Paul to get us started, and look forward to hearing from you both. Thanks, Paul and Elizabeth.
Thanks very much, Karen. So if we go to the first slide, we've got the agenda for our session today. So what I'm going to be looking at is some changes to the flexible working regime in the UK, some other changes to family-friendly legislation, the new duty to take reasonable steps to prevent sexual harassment, the use of NDAs. I'm then going to hand over to Elizabeth Graves, who's going to give an update on a couple of major EU directives, the Pay Transparency Directive and the Corporate Sustainability Reporting Directive. So that's our agenda for today. As Karen says, there should be an opportunity at the end, provided we don't run over too much, to ask some questions. But if you do have burning questions in the meantime, please do put a message in the chat, or contact Karen, or put a hand up or whatever, and we'll endeavour to answer those as we go along. Okay, so if we just move on to the next slide, we can talk about flexible working. So flexible working, or the right to request flexible working, has been around since 2003. If you go to the next slide, sorry, Emily, that'll be fine. So what we've set out on this slide are the changes that came into force from the 6th of April this year. Actually, if you look at the left-hand side of this slide, that's effectively what's not changing. So it remains a right to request flexible working. It's not a right to work flexibly, and that's an important distinction. So, and a right to or the request for flexible working can be any number of things, but it has to be a change to hours or the times of work. So effectively the number of hours, it could be the times that people work or their place of work. And obviously, particularly since COVID and the pandemic, we've had a lot of requests, employers with a lot of requests for employees to continue working from home for all or a large part of their working hours. The employer needs to handle those requests reasonably. There is an ACAS code that provides guidance in relation to how requests should be handled. But in essence, it's important to understand that the tribunals will effectively not go behind the employer's business reasons. Although that said, the employer can only refuse a request on 8 specified grounds. And these haven't changed, but it's worth having a reminder. The 8 grounds are the burden of additional costs, a detrimental effect on the ability of the employer to meet customer demand, an inability to reorganize the work among existing staff, an inability to recruit additional staff to cover any gaps effectively, a detrimental impact on quality, a detrimental impact on performance, insufficiency of work during the periods the employee proposes to work, or planned structural changes. So some pretty broad categories on which employers can refuse flexible working requests, but they do need to fit the reasons for the refusal into one or more of those 8 grounds. Now, what's changed is that the right to request flexible working used to only be available to employees once they'd served their 26-week qualifying period. That has now gone. So the right to request flexible working is now a day one right. So you can recruit an employee to work full-time in your London office. They sign a contract to that effect. On the first day of their employment, they can say, well, actually, I don't want to do that. I want to work 3 days a week from home. And you would need to treat that as a flexible working request and follow the relevant process. It also used to be the case that the employee could only make 1 request in any 12-month period, but that's now changed so that employees can make up to 2 requests in a 12-month period. And the timescale for employers to deal with those requests used to be 3 months. and that's been shortened now to 2 months. And that should really include any appeal that the employer gives. There is no statutory right for the employees to have an appeal, but many employers will, as a matter of best practice, and this is encouraged by the ACAS code, give employees the right of appeal if they have refused a request, and you really want to deal with all of that within that 2-month period. There is no requirement now for employees to set out how the effects of their proposed change can be dealt with. So the legislation used to say that the employee had to submit a request in writing, and they had to explain how they felt that the employer would be able to cover any gaps, for example, that may be created by them reducing their hours and all of that. That requirement has now gone. And all of this is now supported by a revised ACAS code of practice. It's very short, it's pretty practical. It sets out what you have to do as an employer. It also sets out what is regarded as being best practice. And I think from a practical point of view, in our experience, most employers deal with requests for flexible working actually outside this statutory regime. They will try and resolve any request to work flexibly informally through a process of dialogue with the employees. And really, it's only where you get to the stage that the employer is unlikely to be able to find some kind of compromise that effectively the employee will then have to submit their formal request through the regime. The sanctions for breach of the regime remain very limited. So effectively, where the employer is not dealing with it in accordance with the requirements, the process requirements in the legislation, the maximum award that the employee can get is 8 weeks' pay, and that is subject to the cap on a week's pay. So the maximum at the moment is £5,600 in terms of compensation. But the much greater risk for employers is either that the employee will make a claim for indirect sex discrimination on the basis that it's far harder for, generally harder, recognised as being harder for women to comply with a requirement to work full-time or to work from an office location, for example, and the employer will then need to justify those requirements as a proportionate means of achieving a legitimate aim. Or the employee, if they're disabled, may say that the refusal of a request amounts to a failure to make reasonable adjustments, and there the compensation could be much more significant if it's classified as a discrimination claim rather than just a breach of the flexible working regime. So definitely worth bearing those in mind. That's effectively all I was going to say in relation to the flexible working regime. Happy to take questions at the end if anybody has any. Otherwise, we'll move on to the next slide, Emily. And some other family-friendly changes. So we've got now, from the 6th of April, the introduction of a new statutory right. Now, this is a new statutory right for carers leave. And this effectively entitles an employee to unpaid leave to a week's unpaid leave in a rolling period of 12 months to provide for or arrange care for a dependent with a long-term care need. And that can be taken as a minimum of half a day up to a maximum of 1 continuous week. And this is a day one right as well. So this is something that applies to employees as soon as their employment starts. So for these purposes, who is a dependent? A dependent includes here a spouse, a civil partner, a child, or a parent. It also includes somebody who lives in the same household as the employee, but not as a tenant or a lodger. So it might include, for example, your a boyfriend, a girlfriend, or whatever, something like that. Or it could also include anybody who reasonably relies on the employee to provide their care or to arrange for their care. So that could, for example, be another family relative, an uncle or an aunt, for example, who lives nearby, who relies on the employee to provide them with that care. So all of those people would be caught if they have a long-term care need. And a long-term care need is an illness or injury, whether physical or mental, which requires care of more than 3 months, or the relevant individual, the dependent, has a disability, or they require care because of old age. Okay, so all of those people would be caught. So in terms of actually exercising the right, the employee needs to give notice to the employer, and that notice should be either twice as many days as the period of leave they're required that is being requested, or 3 days, whichever is the greater. So if somebody wants just to take half a day's leave, they'll have to give the employer 3 days notice. If they want to take a week's leave, they'll need to give 2 weeks notice. And the same employment protections apply here as with the other forms of family leave. So there's protection from dismissal. So if an employee takes advantage of this right and is then dismissed or treated less favorably in some other way, that would give rise to a claim. The employer does have the right to postpone the leave, but they can't postpone it for more than 1 month, and they can only postpone where the operation of the business would be unduly disrupted. The employer must state the reasons for that and the dates when the leave can be taken within that following month's period. So we haven't had, to be honest, many questions from clients in relation to this. I think it's something that most employers will be able to accommodate relatively easily. In fact, many I'm sure do or have been doing on an informal basis anyway. But again, if anybody has any particular questions or queries, then do let us know. Otherwise, we'll just move on to the next item, which is, I think, does have more practical significance for employers, maybe a little bit more difficult to implement. And this is strengthening protections for employees who take maternity leave or other forms of family leave, and gives them significantly increased protection against redundancy. So we're probably all familiar with the right that employees on maternity leave have had. In the event of a redundancy exercise, they have priority for any suitable alternative employment that may be available. They have that priority in over other employees. Well, that protection has now been extended quite significantly. So it's not just employees on maternity leave, it covers people on adoption leave and taking shared parental leave. And it's a right to be offered that suitable alternative employment where that exists. Obviously, if there is no suitable alternative employment, then it doesn't exist. But the period of protection has been significantly extended. So it now begins on the day that the employer is notified of the pregnancy, and it ends 18 months after the child's birth, or 18 months after the date of adoption, or where the employee takes shared parental leave 18 months after birth, where the employee takes more than or at least 6 weeks shared parental leave. Where the employee takes less than 6 weeks parental leave, the protection only applies for that period of shared parental leave. Now, I think in redundancy exercises, this is actually going to cause quite a few headaches. So I think you as employers will need to consider very carefully which of the employees who are subject to a redundancy exercise, who are put at risk, may have this priority. I think that we may find employees actually using this right tactically. So employees, for example, taking shared parental leave where otherwise they might not have done. Employees potentially notifying employers earlier in relation to pregnancies, so they get that protection from as soon as the notification has gone in. And the other issue, I think, is we're going to find far more competing requests because we've significantly expanded the pool of employees who are going to be protected. So we're going to find far more occasions where there are a number of employees who have this protection. And the question then is, well, how do you then decide who should be selected for the suitable alternative employment if, for example, there's one role left, but you've got 4 employees who have priority? And I have to say the law is not very clear on this point. There's very little and certainly no helpful case law. The ACAS code suggests that you should manage this by assessing the individuals against other criteria such as skills, knowledge, or experience. That's not actually what the legislation specifically says, but seems to me to be a sensible way of proceeding in the absence of any guidance from either from Parliament or from the courts. So I think a few practical issues for us to bear in mind in the context of redundancy exercises going forward. And then if we move on from there, a few changes to the paternity leave regime as well. Again, these ones are not particularly significant. And again, we've had few queries from clients in relation to this, but there are changes to the way that leave and paternity pay can be taken. So it now no longer needs to be taken in a consecutive block of 2 weeks. It can be taken in 2 non-consecutive blocks of 1 week. And it can be taken at any point in the first year after the birth or adoption of the child. So it doesn't, previously it had to be taken within the first 8 weeks. So gives employees a lot more flexibility in terms of when they can take that paternity leave. And the notice period, employees, in most cases, will have to give the employer 28 days notice prior to taking the leave. As I say, relatively small changes, not too difficult to implement in practice. Then just moving away from the family-friendly rights changes there, and looking at sexual harassment. Obviously, this has been a huge topic ever since really the Me Too campaign, the Time's Up campaign, the revelations in relation to Harvey Weinstein back in October 2017. A significant focus in relation to both sexual harassment and also the misuse by employers of non-disclosure agreements, which we'll look at in a second. But what we now have is from October 2024, there will be a new duty on employers to take reasonable steps to prevent sexual harassment of employees in the course of their employment. And the sanction here is that where you've got a sexual harassment claim and the employee is successful, if they can also show that the employer has failed in its duty to take reasonable steps to prevent sexual harassment, their award of compensation can be uplifted by up to 25%. So this is not a freestanding right that employees will be able to have to say, you've breached this duty, I want some compensation. They actually have to have a claim first. So it actually has to be a sexual harassment claim, which they bring, and then they will tack on effectively this potential uplift by showing that the employer has failed in their duty. There is going to be a revised Equality and Human Rights Commission Code of Practice and government guidance that hasn't come through yet. But actually the existing EHRC guidance is actually very helpful in this area anyway, and it's definitely worth having a look at if you're looking at implementing this duty. So we're working with a number of clients on what they should be doing to comply with this duty. And obviously it's something that employers have been taking steps to ensure that there's no sex harassment in the workplace for many years. But I think it's just this new duty has caused them to redouble their efforts in this sense and to revise the process and practices that they've had in place. So if you look at the existing EHRC guidance in this area, they talk about the importance of employers developing effective anti-harassment policies, and I'm sure all of you will have those in place. They also talk, though, about the importance of engaging staff in other ways. So by conducting staff surveys, by conducting exit interviews, by raising awareness generally of the policies and the way in which people can raise complaints, what they should do if they experience complaints, etc. Also, employers taking proactive steps to reduce the risks of sexual harassment occurring in the workplace by identifying particular risk areas. And again, I think this is an area which employers are beginning to do or have been taking more action in relation to. So looking, for example, where there are particular power imbalances in the workplace, encouraging managers to be aware of that and how they should be handled. The use or misuse of alcohol at work, social events, for example. I mean, we do a lot of sexual harassment investigations, both advising on them and actually conducting investigations ourselves. And the vast majority of them will include some form of alcohol misuse, I would say. So looking at the use of alcohol at social events and in the workplace generally, I think is something to be considered. Other areas, making sure you've got proper reporting lines and that employees can report sexual harassment in a variety of ways. So not just through HR and raising that directly with line managers, for example, in person, but also making sure there are confidential whistleblowing procedures in place that allow them to raise issues anonymously, either if they've been the victim themselves or if they've seen something themselves. And again, we've got most of you, I'm sure, will have those processes in place, but it's something that we're regularly asked to investigate anonymous whistleblowing complaints about sexual harassment, which people may have experienced or seen themselves. Training, of course, again, the importance of training workers on what sexual harassment is, what to do if they experience it, either as the victim or as a witness, and how complaints should be handled by managers. And again, we're seeing more and more employers looking to roll out or to revise the training they've been offering in that area. Often the case that employees will get trained on this issue when they arrive in a firm, but that training won't be updated. We've had issues showing that the employers have been taking reasonable steps in the context of handling discrimination complaints and harassment complaints, not being able to show that training has recently been updated. The relevant individual might have done the training 5 or 6 years ago, but not within the last year or two. And then also looking at issues around how complaints are dealt with in practice. So what are the procedures you've got in place? Are you taking these issues seriously? Are you taking appropriate disciplinary action where complaints are found to be well made out? And also the issues around dealing with third parties and the risk of third parties, because harassment might not just occur as a result of your own employees misbehaving, but also through the acts of third parties. So sex harassment by clients, sex harassment by suppliers, for example. So quite a lot, I think, actually. The law here is very simple. It's a very short piece of legislation, but actually quite significant ramifications, quite a lot for employers to do. And then the final topic for me is in relation to the use of NDAs. And this very much follows on from what I've been saying around sexual harassment. So since the Me Too and the Time's Up campaign in 2017, 2018, there's been a big spotlight on sexual harassment and also the misuse of what's perceived to be the misuse of non-disclosure agreements and confidentiality agreements as a means of deterring victims of sexual harassment from disclosing their details to authorities and coming forward. And I think probably the most egregious example, many of you will be familiar with, the case of Zelda Perkins and Harvey Weinstein, where I think the NDA there even prevented her from going to get medical advice or speaking to lawyers without the approval or notification of Weinstein's lawyers. So that was obviously particularly, as I say, particularly egregious example, not the kind of NDA confidentiality agreement that we would normally see in place, but it has focused, I think, a lot of attention. So you had the Women and Equalities Committee commencing an inquiry into the misuse of NDAs. They reported on the 11th of June 2019 and made a series of recommendations. Following on from that, you had a government consultation on appropriate measures to prevent the misuse of NDAs. That responded in July 2019, reiterated the government's view that NDAs are or can be serve a legitimate purpose, but using them to prevent victims from speaking out or intimidating them must be prohibited. We've also had regulatory guidance from our own regulator, the Solicitors Regulation Authority, on what is or isn't appropriate, and we've adapted all of our settlement agreements and employment contracts to make it clear that nothing in that agreement, nothing in that confidentiality clause can prevent employees from raising issues with law enforcement authorities or seeking medical advice or going to relevant regulators. But the government now have actually announced that they are proposing to introduce legislation as soon as parliamentary time allows to clarify that NDAs cannot be legally enforced if they prevent victims from reporting a crime. So that's where we currently are. So disclosure will be permitted if relevant to criminal conduct. So information can be discussed with the police or other law enforcement bodies, lawyers or other support services such as counsellors or medical professionals. So I don't know, Karen, if there are any questions for me or anything that have come through, but I'm about to otherwise I'll hand over to Lizzie.
Before you hand over, I do have one question for you, Paul, relating to carers leave.
Oh, yeah.
From your experience with your clients, how many companies are actually offering paid carers leave as a differentiator from their competitors? Do you have any sense?
To be honest, I'm not sure, but I think that many of them will actually have offered that informally in any event and said, so that when employees have said, look, I need to take some time off to look after my aged mother or whatever, or because I've got an emergency because my child's very ill, then I'm sure most the people on this call, and I'm sure many employers will effectively carry on paying the employee for that, for at least a week or so, as the carers leave allows. So I haven't necessarily seen employers seeking to differentiate themselves, but as I say, we haven't had many queries on this. I don't know, Elizabeth, whether you've had any particular experience of that.
No, Paul, I haven't had any clients who've come to me saying they do want to enhance those statutory entitlements to provide for additional pay on top, but they have, for example, looked at whether holiday is at market levels so that employees have greater leave entitlements in any event.
Thanks, Karen. I'll hand over to Lizzie then.
Thank you, Paul. So we're going to move on to the slightly drier topic now of 2 European directives. There is unfortunately a tendency to use these dreadful abbreviations whenever talking about European directives. And I was in the States 2 weeks ago doing a session on ESG when somebody leant across the table about 30 minutes into it and just said to me, "What is this awful CSRD thing?" So I'm reminded to tell you all that, of course, the CSRD is the Corporate Sustainability Reporting Directive, an EU directive which came into force last year on the 5th of January and has disclosure rules that will apply to different types of organisation between this year, 2024, with first reporting in 2025 and going through to 2028 and beyond. Now, EU member states have until the 6th of July to transpose the CSRD into their own national law, so we're still waiting for some detailed rules on that. The purpose of the Corporate Sustainability Reporting Directive is to extend existing non-financial and sustainability reporting requirements which exist under a previous nattily named NFRD directive to bring more organisations in scope and to encourage organisations to disclose more information about what are described as ESG factors. And that touches on some reward areas for those of you on the call. And a significant number of workforce disclosures generally. And we don't have time, unfortunately, today to go through all of those. So I'm going to concentrate really on the picture in relation to reward and later, and particularly gender pay. So the CSRD significantly extends the number of organisations that will be required to report. It's estimated that the current NFRD applies to about 11,500 companies, covering listed companies, banks and insurance companies and large companies with 500 employees in the EU. It's thought that the extended scope will be around 50,000 companies within scope of the CSRD. And I saw an article in the Wall Street Journal saying that it's thought that there's 50,000 within the EU, but actually the number of what are called third country undertakings, so companies incorporated outside the EU who may have to report under the CSRD, is more like 11,000. So very large extension of those reporting requirements. So the first organisations will have to report from 1st of January 2025 for their financial years that begin on and after the 1st of January 2024. And that will be those organisations already within scope of the existing NFRD. Next to come will be what are known as large undertakings who aren't currently subject to the reporting requirements, and they'll have to start in 2026 for their financial years that start on or after the 1st of January. And then following on from that will be the SMEs and then what are known as the third country undertakings. I'm not going to go into detail about how you determine which of those tests you fall within and which type of organisation you are. So spoiler alert, I'm not going to answer any questions on that, but I can refer them to people who can advise on that if you need help with that. But I think the key point here for many organisations is that the scope is potentially extraterritorial if your operations within the European Union hit one of the thresholds. So under the directive are a set of what are called the EU Sustainability Reporting Standards that were agreed last year and which specify the information that has to be disclosed. The directive itself simply says that organisations within it will need to report on gender and equality pay alongside other workforce requirements. What I want you to focus on is the gender pay reporting requirements under CSRD, and those sit within what are called the EU Sustainability Reporting Requirements. requirements. Now, what most organisations are doing at the moment is applying something which terrifyingly is called a double materiality assessment, which I understand is undertaken with your auditors and looks at two different types of materiality test. One about impact, so the undertaking's actual potential positive or negative impacts on people and the environment over the short, medium and longer term. And then the second test is about financial materiality, so the material financial effects of the undertaking triggered by sustainability related matters. And the topical standards, which can include gender pay reporting, will require an undertaking to report information that meets at least one of those two materiality thresholds, and it can omit information that isn't material for its business model and activity. Now, in terms of when these reporting requirements, which will include some information on gender pay gaps, will come into effect, that depends on the type of organisation that you are and the outcome of your double materiality assessment. And I'm going to come back later and talk about what's involved and how that sits with the second of the directives that I want to move on and talk to you about now. So, Emily, if we could just go on to the PTD, which is, of course, the European Pay Transparency Directive. So this is a directive which is entirely about equal pay and gender pay gap reporting, rather than the CSRD, which is a reporting requirements directive and has an element that deals with gender pay gaps and equality reporting. So if we could just go back to the, oh no, that's the right side, apologies. So this directive was adopted last June and it has to be implemented by member states by June 2026. And as any of you who will come to the session we held with PARC back in September last year will know, that is, despite sounding a long way off, actually quite an ambitious timescale for the amount of work that companies subject to this directive will have to do to be ready for it. So what does the EU Pay Transparency Directive require? Well, it has a number of what we call day one rights that will apply from June 2026 and will affect how organisations share information about their pay practices and how they hire. And then it has gender pay gap reporting requirements, which I'll come on to in a moment. So the day one rights, as we call them, that will apply from 7 June 2026 will apply to most organisations regardless of the number of employees that they employ within the European Union. So if you have one employee in one country within the European Union, you will have to comply as regards that employee with these day one rights. So the first of those is that employers will no longer be permitted to ask candidates for jobs about their pay history with current or former employers. And that mirrors a rule that applies in a number of US states already, what's called pay secrecy prohibitions. So you will be having to set pay based on market practice and appropriate standards rather than what your candidate is currently paid, because you won't be able to ask them for that information. You will also need to provide candidates with information about what's called the pay range for their for the role they're applying for before you interview them. So in some countries this is already a requirement, in others it will be quite new, and it will likely mean that, as in some US states, job advertisements will need to include information about the pay range for the role. Now, the most onerous of the obligations under the directive is the third bullet point, and that is that you will, as an employer, have an obligation for your EU employees to give them information about the average pay gap by gender for their category of workers. A category of workers is workers who do equal work or work of equal value. So you are suddenly going to be required to give employees on a plate the information that has prevented them historically in most countries from bringing equal pay litigation. And we only need to look to what's happening in the UK at the moment, particularly the way that equal pay has grown in the private sector in retail, to see how significant those claims can be. Workers will also be entitled to information about the criteria used to determine their pay and their pay progression. That will have to be done in accordance with non-gendered objective criteria. So those are the basic rights that will apply from June 2026. Emily, if we can move on now to the next slide, I'm going to look then at the gender pay gap reporting requirements. So the EU Pay Transparency will require all employers who have more than 100 employees in an EU member state to publish information about the gender pay gap for those employees. Now, that information that has to be published will be at the overall entity level, so it will be very similar to the UK requirements at the moment, the average pay gap and the average bonus cap as between men and women. The first reporting requirement will be in 2027, so a year after the member states' laws will have come into effect. And the employers who will have to first publish will be those who have more than 250 employees in that specific country, and we think that entity, are not entirely clear. They will do an annual report from June 27, and then medium-sized employers who have 150 to 249 employees will publish their first report in 2027 as well, but they'll only have to do that every 3 years. And then smaller employers between 100 and 149 employees will have to publish their report every 3 years, but their deadline for the first reporting is not until 2031, so some way off for them. In theory, employers who have less than 100 employees in an EU member state, and we think by entity, won't have to publish gender pay gap information at all, but that can be changed by local law. So a member state could choose to impose more national onerous reporting requirements. And these requirements will build on existing local laws. So although the gender pay gap reporting is quite similar to what exists in the UK and Ireland, it's actually very different to the rules that exist in France. And so there may be almost 2 reporting standards that employers have to comply with. Where the report identifies a gap of 5% or more, so the average gender pay gap, which can't be objectively justified, then there will be an obligation for the employer to enter into what's called a joint pay assessment in conjunction with their worker representatives. So what employers may find themselves having to do from 2027 onwards is if they can't justify their gap of 5% or more by reference to what we call genuine material factors, then they'll actually have to negotiate measures with their works councils or trade unions to try and close that gap. We can move forward then to the next slide here. Just to put this in the context of what is happening around the world, we think that the EU Pay Transparency Directive is the most onerous set of obligations for an employer anywhere in the globe at the moment. There has been increasing requirements in the US, but those are largely around transparency in relation to things like job advertisements and prohibitions, less in relation to gender pay gap reporting, and certainly not the level of information that workers will be entitled to about the gap for their category of workers within the EU. So we're still waiting, and I very much doubt we'll see any local implementing legislation until 2025 at the earliest. And we at Evershed Sutherland are working with a number of clients on actually getting ready for both pay gap reporting and the other transparency measures. And what we have observed is that many companies have been focused on pay gap reporting, probably because of CSRD, and actually now having to think about how significant these other measures might be, and starting to do their pay equity analysis in different areas to actually find out what their gaps will look like for when they have to share those with employees. We're also seeing some challenging issues emerging around how to determine who's a worker, because that test sits under local law. It's not set by the directive. So if you have in your organisation workers by the local law standards, then they will be within scope of all the directive requirements. What's covered by pay in each country? The directive covers, has a very, very wide definition of pay, which potentially includes things like pensions as well. There's been some debate in the media about the risks of what are called single source claims. So employees will be able to compare themselves for equal pay purposes with employees in other countries where their pay is set by a single source. So for example, if you have a compensation philosophy that's set by your US or UK headquartered company, you may have a single source, but we think that you will still be able to justify pay gaps based on local market practice. So for example, it's typical in the US to offer a much higher level of LTI than perhaps in other countries in Europe. And then the really challenging area that we're seeing is just the overlap between the European Pay Transparency Directive and the other requirements. And to finish off, I've got a little slide for you just at the end where we have mapped out for you how the CSRD and the Pay Transparency Directive requirements fit together. So you can see, as I mentioned earlier, that if you look at the box on the yellow box, 1, 2, 3, 4, 5, 6, 7, 8, 9 blobs along, that the first pay transparency reporting obligations on gender pay gaps will come into force on 7th of June 2027. But there is a risk that companies that are in scope of the CSRD might actually have to report on gender pay gaps in the 2025 year based on the 2024 financial reporting year. Now, there is a difference between the disclosures that you have to make. So for CSRD purposes, you only have to disclose the average pay gap at the undertaking level, and you have a choice whether you want to go and disclose at the category of workers level. I'll be very surprised if any employers wish to do that. And you can also choose to break down your gender pay gap reporting by country or segments as well. But then there's an additional complication under the CSRD, which is that if you've conducted your materiality assessment and you do think you have a problematic pay gap that might impact on people, then you may need to do more than simply the overall reporting requirement in relation to that. So for many companies who've been looking at the Pay Transparency Directive and thinking they've got until 7th of June 2027 to report, they've got to remember that employees are entitled to their information about pay gaps at worker level and by category from 7th of June 2026, and that actually they might be having to put more information into the public domain if they're covered by CSRD earlier than 2027 as well. So I'm going to leave you with that. I think we're going to share the slides afterwards, and if anybody wants to talk about any of these issues, then very happy to take questions later or offline as well.
Thanks, Elizabeth. A lot of information there. We have got actually a couple of questions that have come in relating to your part of the presentation. The first question is regarding the greater than 5% pay cap. Does this relate to the overall pay gap unadjusted, or for jobs of equal value only in terms of the justification?
My recollection is that it applies to both, because there is the requirement to publish your average pay gap and your average bonus gap, and where that reveals a cap of 5% or more, then you have to, and you can't explain it away, you have to go into a negotiation. But you also have to calculate the average gap at the category of workers and make that information directly available to workers and workers' representatives. And I think the 5% negotiation is triggered with that as well.
Thank you. When can we expect member states to publish their methodologies for calculating the gap? And is there any chance of the definitions of pay actually aligning across Europe?
So the directive does have its own definition of pay. I think there is some risk that that will be interpreted differently at member state level. We simply don't know. If the UK were within the EU, we would probably have a very well coordinated timeline for the legislation that's going to be published. But our experience with other European member states is that it just doesn't happen like that. So we at Evershed Sutherland are working on trackers for clients so that they will be able to find out when there are proposals for new legislation in the different EU member countries, and what that legislation is when it's published and how it might differ from the directive requirements. Many EU member states may simply cut and paste the directive, but there is a risk that others go further than that. And I'm afraid, can't tell you when we're going to have that legislation, but my experience based on the whistleblower directive is I think it's highly unlikely we'll get anything this year. The earliest would likely be 2025, and we may get some of it in 2026. Poland was, of course, non-compliant with the whistleblower directive for some time and hadn't published legislation even after the deadline to do that had passed. So it's a really difficult issue to deal with, and I think that's why we're encouraging people to start with what the directive requires in their preparation rather than sit and wait for local legislation to come around.
Does anybody else have a question at this stage?
A general question that'll probably evolve as I'm asking it. Where you have to communicate a pay range for a particular role, bearing in mind that companies often identify something like 15 preferable skill areas, not all of which they demand in a particular job, would it be acceptable to say that the pay range for this job is between 50 and 100K, depending on the extent to which people meet our range of skill requirements?
I mean, I think that's potentially what may happen, and certainly we've seen in the US companies publishing very wide pay ranges. What's going to be important is the methodology that sits behind it. So that sounds, Phil, like it would have some factual basis for why you're publishing such a wide pay range. We just don't know what the enforcement is going to look like yet.
Because, of course, the justification would be depending on our personal judgment of the extent to which you personally meet those requirements. And that becomes very, very vague, doesn't it?
That's right. But you're going to have the job evaluation schemes that sit behind all of this to justify why you pay what you do for that particular role.
A huge thank you to both Paul and Elizabeth. It was informative as opposed to terrifying, and certainly lots of things for us to keep track of. But thank you both. Look forward to seeing you both again soon. And thanks everyone for joining today. And as Elizabeth suggested, if you have any questions that you would like to ask directly of Elizabeth and Paul, then do feel free to contact them directly, or if you would like us to facilitate a connection, then of course just get in touch with me and we can make sure that that happens. But for now, thanks very much, and look forward to seeing you all soon.